The information provided in this video is for educational purposes only and does not constitute legal advice. The content of this presentation is not intended to be a substitute for professional legal counsel. Watching this video does not create an attorney-client relationship. You should always consult with a qualified and licensed legal professional for advice regarding your individual situation and specific legal issues. It's 2 in the morning. The only light for miles is the flashing of your hazard lights and the cold, blue-white glare of a state trooper's strobes painting the trees. Your heart is hammering against your ribs, a frantic drumbeat in the sudden, shocking silence after the crash. Your car is a wreck, crumpled metal and shattered glass. The other driver is sitting on the guardrail talking on his phone, and you just overheard him say the words, "My neck is starting to feel stiff." A cold dread washes over you. You know with absolute certainty that this single moment could derail your entire life. The trooper walks over, notepad in hand. "All right," he says. "Tell me exactly what happened. What do you say? What do you never say? Do you apologize? Do you mention you were glancing at your GPS? Do you say anything at all?" In this moment of pure panic, your brain is screaming for an answer, for an expert to tell you exactly what to do to protect yourself. But who can you possibly call at 2 in the morning? For millions of Americans, the answer is a 24-hour legal hotline. It sounds like something out of a movie. A secret number you can call anytime, anywhere, and get a real lawyer on the line in minutes. Sounds too good to be true. And for most people, it remains a complete mystery. Is it a scam? Is it a real lawyer or just a glorified call center in another country? And how in the world does it actually work? Today we are pulling back the curtain. We're going to dissect the entire ecosystem of 24-hour legal hotlines in the United States. We will expose how they operate, who's really on the other end of that phone call, what they can and absolutely cannot do for you, and the critical question, could one of these services be the single most important phone number you ever have? By the end of this video, you will understand this powerful tool better than 99% of the population, and you'll know how to tell the difference between a genuine lifeline and a predatory marketing gimmick. Let's be honest, the legal system is intentionally complex. It's a game where the rules are written in a language most of us don't speak. When you're in a vulnerable situation, a car accident, a dispute with a landlord, a sudden issue at work, you are at a massive disadvantage. The insurance adjuster you're talking to? They handle hundreds of claims a year. They know the script. They know the exact phrases to use to get you to admit partial fault. The debt collector calling you at dinner time? They are trained in psychological tactics to pressure you into paying, whether you owe the debt or not. They have the playbook and you don't. A legal hotline is designed to be your playbook. It's meant to level the playing field instantly by putting an expert in your corner when you need it most. Imagine facing a pop quiz that determines your financial future, but someone just slipped you the answer key. That's the promise. But here's where the confusion begins, because legal hotline isn't a single defined thing. It's a broad term that covers a bunch of different business models, and if you don't know which one you're dealing with, you could be in for a nasty surprise. First, you have the most common type, the legal insurance plan. Companies like Legal Shield or ARAG are the big players here. You pay a monthly subscription fee, maybe $20 or $30, and in return, you get access to a network of law firms. This is the model we'll focus on most because it's the most structured. Second, you have legal hotlines as a perk or an employee benefit. Many large corporations and even some credit cards or auto clubs offer a free legal hotline as part of their benefits package. It's a hidden gem that millions of people have access to and don't even realize it. Third, and this is the one you have to be careful of, are the free consultation hotlines. You see their ads on late-night TV or on billboards. Injured? Call now. These are typically not neutral advice services. They are lead generation machines for specific law firms, usually personal injury attorneys. Their goal isn't just to give you advice. It's to sign you up as a client. There's nothing inherently wrong with that, but you need to understand their motive. Finally, there are nonprofit and government-funded legal aid hotlines, which are incredible resources for those who qualify, often focusing on specific issues like housing, domestic violence, or elder law. So let's go back to our 2 a.m. car crash. You have a legal insurance plan. You're standing on the side of the road, shaking, and you remember you have the app on your phone. What happens next? You tap the button for Emergency Legal Access. The first voice you hear will likely not be a lawyer. It will be a trained intake specialist. Their job is to do 2 things very quickly: verify that you are who you say you are, and understand the basic nature of your emergency. They'll ask for your name, your member number, and a one-sentence summary of your problem. I've just been in a car accident, and a police officer is about to take my statement. This is a critical step. The intake system is designed to triage your call. They need to know if this is a true, time-sensitive emergency that falls under the plan's coverage for 24/7 support. A question about your will or a dispute with a contractor can wait until morning. A police interview on the side of a highway cannot. Once the specialist confirms your emergency, they will say something like, "Okay, please hold while I connect you to an on-call attorney in your state." This is the magic moment. The system is now dialing out to a lawyer. But who is this person? Are they sitting in a massive call center with a headset on waiting for your call? Absolutely not. The person you're about to speak with is a real licensed attorney who practices law in your state. They are most likely at home, possibly asleep just moments before. They are part of what's called a provider law firm. The legal plan company, the one you pay your monthly fee to, doesn't employ the lawyers directly. Instead, they build a nationwide network by contracting with dozens, sometimes hundreds, of independent law firms in every state. These firms agree to take calls from the plan's members in exchange for a steady stream of business and referral fees. The lawyer on the other end of the line is a partner or an associate at one of these contracted firms. They've agreed to be in the on-call rotation for emergency calls that come in after business hours. So the phone rings and a voice says, "This is Attorney John Smith. I understand you've been in an accident. How can I help?" First, let's talk about who John Smith is. He's not a random person who passed the bar exam. Provider firms are vetted. The legal plans require them to have a certain number of years of experience, to be in good standing with the state bar, and to carry malpractice insurance. They are typically small to mid-sized firms that handle a variety of common legal issues: traffic violations, family law, estate planning, and landlord-tenant disputes. They are generalists, not hyper-specialized experts. The lawyer you get for a 2 a.m. car accident call is likely the same one who might handle a call about a speeding ticket or a fight with a home contractor. This is legal urgent care, not brain surgery. Their job in this emergency moment is not to become your lawyer for a multi-year lawsuit. Their job is immediate damage control. They are there to give you clear, simple, and legally sound instructions to get you through the next 30 minutes without making a catastrophic mistake. They are the voice of calm and reason in the middle of your chaos. They are there to be your playbook. But what does that playbook actually look like in action? What happens when you pick up the phone at 2 a.m., your heart pounding, your mind racing, and dial that number? Who is on the other end of that line? Is it a seasoned 60-year-old attorney with decades of courtroom experience, sitting in a leather chair just waiting for your call? Or is it a fresh-faced paralegal in a cubicle farm 1,000 miles away? The answer is, it's complicated, and it's designed that way for a very specific reason. Let's get one thing straight. The first voice you hear is almost never going to be a partner from a downtown law firm. And that's a good thing. Think of it like a hospital emergency room. When you burst through the doors with a medical crisis, you don't immediately sit down with the chief of surgery. You first talk to a triage nurse. This is a highly trained professional whose job is to assess your situation with lightning speed. They take your vitals, ask targeted questions, and figure out the severity of your problem. Are you having a heart attack that needs immediate top-level attention? Or did you sprain your ankle and can wait a few minutes? The 24-hour legal hotline operates on the exact same principle. The first person you speak with is your legal triage specialist. They might be a paralegal, a legal assistant, or a specially trained intake coordinator. Their job is not to give you legal advice. Let me repeat that, because it's the most important thing to understand about this first step. Their job is not to give you legal advice. Their job is to perform a rapid, accurate diagnosis of your legal emergency. They have a script, a decision tree that they follow with precision. They are trained to listen for keywords, to ask questions that cut through the panic and get to the core facts. What happened? When did it happen? Where did it happen? Who was involved? Are the police there right now? Has anyone been arrested? Is there an immediate threat to your safety or your property? Every question is designed to place your problem into a specific category and onto a specific timeline. Let's imagine a scenario. It's 11:30 p.m. on a Friday. You get a frantic call from your college-aged son. He was at a party, things got out of hand, and now he's in the back of a police car, arrested for a DUI. He's scared, you're terrified, and your mind is a complete blank. You remember you have a legal plan through your employer, and you dial the 24-hour hotline. The phone rings twice. A calm, steady voice says, "You've reached the legal helpline. My name is Sarah. How can I help you?" You start talking, the words spilling out in a panicked jumble. "My son, he's been arrested. I don't know where he is. They said a DUI. He's a good kid. He's never been in trouble." Sarah, the triage specialist, will gently interrupt. "Okay, sir, I understand this is incredibly stressful. I am here to help. First, I need to get some basic information so we can figure out the best next step. What is your son's full name and date of birth?" You tell her. "Okay, and do you know which police department arrested him? Or the city and state where this happened?" You remember your son said he was in a town near his campus. You give her that information. See what's happening? She's not asking about the details of the party or if your son had been drinking. That comes later. Right now, she's establishing jurisdiction. The laws for a DUI in Texas are wildly different from those in California or New York. Knowing where this happened is the first and most critical piece of the puzzle. It determines which set of laws apply and which attorneys in their network are even licensed to help. Next, she'll ask, "Has he been formally charged with anything yet? Has he been read his rights?" You have no idea. "That's okay," she'll say. "The most important thing right now is that your son does not answer any questions from the police until he has spoken with an attorney." Has he already been questioned? This is the second phase of triage, immediate risk mitigation. Just like a triage nurse would tell you to apply pressure to a wound, the legal triage specialist is providing the most urgent, universally applicable instruction: stop the bleeding. In the legal world, that often means invoking the right to remain silent and the right to an attorney. It's not legal advice tailored to his specific case. It's a fundamental, constitutional-level instruction that applies to nearly every single criminal arrest in the United States. It's the first play in the playbook. Now, based on the information you've given her, a DUI arrest, a specific location, the fact that your son is currently in custody, her decision tree lights up. This is not a "let's schedule a call for Monday morning" situation. This is a client needs immediate counsel emergency. She'll say something like, "Okay, thank you for that information. This is an urgent matter, and we need to get an attorney on the line for you and your son as quickly as possible. I am now going to connect you to our on-call criminal defense attorney, who is licensed to practice in that state. Please stay on the line. It may take a few moments to connect." And this is the magic of the system. Behind the scenes, a notification has just been sent to a pre-vetted, local criminal defense attorney who is part of the Hotlines network. This lawyer isn't an employee of the hotline. They are a private practice attorney who has contracted with the service to be available for these exact moments. They might be at home watching a movie or about to go to sleep, but they are on call, ready to respond. The system triages the thousands of calls they might get, ranging from questions about a will, to a dispute with a neighbor, to your crisis, and funnels the true emergencies to the right expert in real time. This is why the first person you speak to isn't the senior partner. It would be an incredibly inefficient and expensive use of that lawyer's time to answer every call, many of which might be simple informational queries. The triage system acts as a highly effective filter, ensuring that the people who need a lawyer right now get one, while those with less time-sensitive issues are scheduled appropriately. So you're on hold. The hold music is probably terrible, but in that moment it's the most beautiful sound in the world because it's the sound of help being mobilized. It's the sound of the system working. You've gone from pure panic and isolation to being inside a process. You've activated the playbook. After a minute or two, the line clicks. A new voice, different from Sarah's, comes on. This voice is different. It's often calmer, more deliberate, and carries an unmistakable weight of authority. "This is Attorney Michael Reynolds," the voice says. "I understand your son has been taken into custody for a suspected DUI. Let's talk about what we need to do right now to protect his rights." You have now passed through triage. You are no longer talking to an intake specialist who can only provide information. You are speaking with a licensed attorney who can provide actual, privileged, and actionable legal advice. And what that lawyer tells you to do in the next 5 minutes can, and often does, change the entire trajectory of the case. It can be the difference between a manageable mistake and a life-altering conviction. The playbook is open, and the lawyer is about to call the next play. And the first play, the absolute non-negotiable first move in this high-stakes chess match, is almost always the same. It's deceptively simple, yet it's the hardest thing for a panicked human being to do. The lawyer's voice, now calm and firm, cuts through the static of fear. "Stop talking. Right now. Do not say another word to them. This isn't just advice. It's a command. It's a lifeline thrown into a sea of chaos. Because in that moment, your most powerful enemy isn't the officer standing in front of you. It's your own mouth. It's the primal human urge to explain, to justify, to make it all go away by finding the right combination of words. We're raised to be cooperative. We're taught that if we just tell the truth, everything will be okay. But the side of a highway at 2 a.m., with flashing lights painting the scene in strokes of red and blue, is not a classroom. It's an arena. And the person you're talking to isn't your teacher. They're your opponent. The lawyer on the phone understands this with chilling clarity. They know that police officers are masters of conversation, trained to extract information you don't even realize you're giving away. Every hesitation, every seemingly innocent answer is a piece of a puzzle they are building against you. You think you're helping. You think you're clearing your name. But what you're actually doing is handing them the hammer and nails to build your own cage. When you say, "I only had a couple of beers with dinner," you think you're minimizing. What the officer hears and what they will write in their report is an admission. The suspect admitted to consuming alcohol before driving. When you say, "My friend was holding it, I didn't even know it was in the car," you think you're deflecting blame. What the prosecutor sees is you placing yourself at the scene, acknowledging the presence of contraband, and creating a link. You're trying to talk your way out, but every word is just weaving the net tighter around you. The lawyer on the hotline is your circuit breaker. They are there to stop the flow of self-incrimination before it burns your entire life down. They will coach you, drill you on the precise, legally fortified words to use. It's not, "I think I should probably get a lawyer, maybe." That's an invitation for the officer to say, "Well, are you asking for a lawyer, or are you just thinking about it? If you've got nothing to hide, we can clear this all up right now." That ambiguity is a legal gray area they can and will exploit. No, the words are a formula. A clean, unambiguous incantation that invokes centuries of legal protection. The lawyer will have you repeat it back to them. "Officer, I am invoking my right to remain silent. I would like to speak with my attorney." Let's break down why that phrase is pure legal power. I am invoking. It's an active, declarative statement. You are not asking for permission. You are claiming a constitutional right. This word triggers a legal tripwire. Continued questioning after this point can render any subsequent statements inadmissible in court. My right to remain silent. This directly references the Fifth Amendment. It's a clear, unmistakable signal that the conversation, as far as you're concerned, is over. The police cannot legally penalize you or hold this against you. And the final piece, I would like to speak with my attorney. This invokes your Sixth Amendment right to counsel. Once you make this unambiguous request, all questioning is supposed to cease. Immediately, the lawyer on the phone is your coach, your director. They are preparing you for the performance of your life. Because after you deliver those lines, the pressure is going to triple. This is where the real psychological warfare begins. The officers might change their demeanor. The friendly, concerned cop might suddenly become frustrated, disappointed. "Look, I was trying to help you out here. I was going to give you a break. But if you want to lawyer up, fine. We'll do this the hard way. Get out of the car." This is a tactic. It's designed to make you feel like you've made a mistake, that you've escalated the situation by asking for a lawyer. Your own mind will scream at you to backtrack, to apologize, to start talking again just to make the confrontation stop. The lawyer on the phone has already warned you this will happen. They will try to make you feel guilty for protecting yourself. Their voice will echo in your memory. Do not fall for it. Stay silent. Your silence is your shield. The hotline lawyer is also preparing you for the next phase. What if you're already at the station? What if you're in that cold, gray, windowless room? The lawyer paints the picture for you so you're not walking in blind. They'll tell you about the good cop, bad cop routine. It's the oldest trick in the book, but it works because it preys on basic human psychology. One detective will yell, threaten you with the maximum possible sentence, paint a grim picture of your future. Then he'll leave and his partner will come in, offering you a coffee, speaking in a soft, understanding voice. "Listen, my partner's a hothead, but I can talk to him. I can help you. You just have to work with me. Tell me what really happened." The lawyer on the phone is the voice of reason cutting through that manufactured drama. They are not your friends, they'll insist. The good cop and the bad cop both have the exact same goal, to get a confession. They are a team, and you are their target. They will also warn you about the lies. Police are legally allowed to lie to you during an interrogation. They can say your fingerprints were found on the weapon. They can say they have an eyewitness who identified you. They can say your co-defendant is in the next room cutting a deal and pinning it all on you. These are all permissible strategies designed to make you feel hopeless, to make you believe that the only way out is to confess. Without that 24-hour hotline lawyer in your ear just minutes before, you would walk into that room and believe them. You would feel the walls closing in, and your survival instinct would kick in, telling you to talk, to negotiate, to say anything to make it stop. But with that one phone call, you are now armed. You know the playbook. You know it's a performance. You know that your only line in this entire play is, "I want my lawyer." The advice goes beyond just staying silent. The lawyer will give you a rapid-fire list of don'ts. Do not consent to any searches. Not your car, not your pockets, not your phone, not your home. They will tell you that if the police had enough evidence to legally search, they would get a warrant. By asking for your consent, they are often admitting they don't have enough. Giving consent is just waiving your Fourth Amendment rights for free. Don't sign anything. Don't agree to a DNA swab. Don't take a polygraph test. Don't try to outsmart them. That one phone call transforms you. You go from being a scared, isolated individual vulnerable to all the pressure and tactics of the state, to a fortified position. You are no longer just one person against a system. You are one person plus a legal professional who knows the system inside and out. The power dynamic shifts ever so slightly back in your favor. You are no longer just reacting to their moves. You are executing a defensive strategy given to you by an expert. Finally, the lawyer will lay out the immediate next steps. They'll tell you what they're doing on their end. They might be calling the station to inform them. They are now your legal counsel of record. They might be dispatching an associate or coming down themselves. They'll tell you, "I am on my way. Do not speak to anyone until you see my face." This is a promise. It's the light at the end of the tunnel. Help is not just an abstract concept anymore. It has a name, a voice, and it is in motion. The isolation is broken. You are no longer alone. The initial phone call, that desperate reach into the digital darkness, has successfully established a beachhead of legal protection. The first, most critical battle, the battle for your silence and the preservation of your rights, has been fought and, if you follow the instructions, won. But this is just the beginning. The lawyer's immediate instructions have stopped the bleeding, but the wound is still there, and the full force of the justice system is just now beginning to mobilize. The adrenaline of the moment is gone. The flashing lights have faded into a throbbing headache. You're home, or you're in a holding cell waiting for bail. And the sun is coming up on a brand new, terrifying reality. That 3 a.m. phone call wasn't a magic spell that made the problem disappear. It was a tourniquet. It stopped the immediate, life-threatening bleeding. But now, in the cold light of day, the real complex surgery is about to begin. This is where the 24-hour legal hotline transitions from an emergency first responder into the architect of your defense. Your phone rings again. It might be hours later, maybe the next business day. It's not the same gruff, sleepy-voiced attorney who walked you through the initial crisis. This person is different. They're professional, calm, and methodical. This is your intake specialist, your case manager, your paralegal. The title varies, but the role is universal. They are the grand central station of your legal problem. Their job is to take the chaotic, fragmented story you're living and translate it into the structured, logical language of the law. They will start by verifying who you are, but then the questions begin, and they are relentless. They're not just asking what happened. They are mining for data. What was the exact date and time of the incident? What is the full, correct spelling of every person involved, including middle initials? Do you have a police report number? An incident number? A case number? Were there any witnesses? What are their names and contact information? Did you take any photos? Any videos? Do you have any text messages, emails, or documents related to this? Every question feels tedious. You might even get frustrated. You want to talk about how unfair it all is, how you're the victim here. But they will gently, persistently steer you back to the facts. Because in the legal world, feelings are noise. Facts are ammunition. They are building an arsenal for the attorney who will eventually take your case. Every piece of information you provide is another weapon they can use, another shield they can raise. Your foggy memory of the street signs becomes a verifiable location on a map. The name of the other person involved becomes a public record search for past incidents. That police report number is the key that unlocks the official narrative your lawyer will have to either support or dismantle. This intake process is also where the crucial and often uncomfortable conversation about money happens. Because while justice should be blind, the people who work within the system need to pay mortgages and keep the lights on. How this works depends entirely on the type of hotline service you're using and the nature of your legal problem. First, there's the subscription model. This is for services like Legal Shield ARAG, or even some premium credit card benefits. You pay a flat monthly fee, something like $25 to $50, and in return you get access to a network of lawyers for a range of common issues. For that fee, a simple consultation, a letter written on your behalf, or a document review might be fully covered. If you need more significant help, like representation in court for that DUI, your membership might cover the first few hours or give you a substantial discount, say 25% off the firm's standard hourly rate. The beauty of this model is its predictability and accessibility for smaller problems. The downside is that it might not cover a catastrophic, multi-year legal battle in its entirety. It's legal insurance, and like any insurance, you have to read the policy to understand the limits of your coverage. Second, you have the retainer model. This is the classic way most people hire a lawyer, especially for criminal defense, family law, or business litigation. After the initial consultation, if you and the law firm decide to work together, they will quote you a retainer fee. This is a lump sum of money you pay up front. It could be $2,000, $5,000, $10,000 or more, depending on the complexity of your case. This money goes into a special trust account. It is still your money. The law firm then bills their time against that retainer. Every phone call, every email, every document they draft, every hour they spend in court is tracked and deducted from that balance. You'll get a monthly statement showing you exactly where the money is going. When the retainer runs low, you'll be asked to replenish it. This model ensures the law firm is compensated for their work as they go, and allows them to dedicate the necessary resources to your case without worrying if you're going to be able to pay at the end. The hotline's role here is to connect you with a firm whose retainer structure and hourly rates are appropriate for your situation. Finally, there's the contingency fee model. This is the model you see advertised on billboards. A no fee unless we win. This is used almost exclusively in personal injury cases, car accidents, slip and falls, medical malpractice. In these cases, you're the plaintiff, the one seeking money for damages. A reputable lawyer knows you probably can't afford a retainer, especially when you're out of work with medical bills piling up. So they make a different deal. They take your case for free. They pay for all the upfront costs, the filing fees, the expert witnesses, the depositions. In exchange, if and when they win a settlement or a verdict for you, they take a percentage of that money as their fee. This percentage is typically around 33%, but it can go up to 40% or more if the case goes to a full trial. This model is a powerful tool for justice. It allows a person with no money to take on a massive insurance company or a powerful corporation. The law firm is essentially betting on you and your case. If they lose, they get nothing and eat all the costs they fronted. The intake specialist will explain all of this. They will be clear about what's covered by the service and what you will be responsible for. Once the information is gathered and the financial arrangement is understood, the next critical step happens: the handoff. The 24-hour hotline service is not your law firm. It is a matchmaker, a highly sophisticated, legally savvy matchmaker, based on your specific problem. A DUI in Phoenix, Arizona, a contract dispute in Miami, Florida, a custody battle in Portland, Oregon. They will dive into their curated network of independent, local attorneys. These aren't random lawyers from a phone book. These are firms that have been vetted by the service. They're checked for their experience in that specific area of law, their track record, their standing with the State Bar Association, and their willingness to work with the hotline's members or fee structures. You'll get an email or a call with a name and a number. Your case has been assigned to the law office of Jane Smith. She specializes in felony DUI defense and has been practicing in your county for 15 years. Her paralegal will be contacting you within 24 hours to schedule your first formal meeting. This is the moment your legal journey gets real. You're no longer dealing with a faceless hotline. You now have a name, a specific person who will be your champion. And from the moment that connection is made, everything you have told the hotline, from the initial frantic call to the detailed intake interview, is protected. It's all covered under what's called attorney-client privilege. The intake specialist, the paralegal, the receptionist at the law firm, they are all considered agents of the attorney, and they are all legally bound to absolute secrecy. This is the sacred trust of the legal profession. It's what allows you to tell your lawyer the whole unvarnished, embarrassing truth, so they can build the strongest possible defense. The file is now built. The financial terms are clear. You've been matched with a local expert. You feel a flicker of hope, a sense that you're no longer alone in this storm. But then you get the official notice in the mail, the one that makes your stomach drop. It's a summons, a notice to appear. Your arraignment date has been set. This will be the first time you have to stand in a courtroom, in front of a black-robed judge, and the words you say next could alter the course of the rest of your life. What are those words? And who tells you what to say? The most important words, the ones that preserve every right you have, the ones that start the entire chess match of the American legal system, are just two: not guilty. Your lawyer, whether it's a high-priced private attorney or a public defender you just met 10 minutes ago, will almost certainly advise you to say them. And if you don't have a lawyer yet, and the judge asks how you plead, you tell them you wish to plead not guilty and are requesting counsel. That's it. It might feel like a lie. You might have been caught red-handed. You might feel an overwhelming urge to just confess, to get it over with, to apologize and hope for mercy. But that urge is a trap. The arraignment is not a trial. It is not the time for your story. It is not the time for explanations or justifications. It is a formal procedural hearing where the court officially tells you what you're being charged with, and you give your initial response. Pleading guilty at this stage is like folding your hand in poker before the flop has even been dealt. You haven't seen the other player's cards, you haven't seen the community cards, you've just given up the pot based on the two cards you were dealt in the dark. Pleading not guilty does one crucial thing: it buys you time. And in the legal world, time is everything. It's the time your new lawyer needs to file a formal request for discovery. Discovery is the legal term for all the evidence the prosecution has against you. The police reports, the witness statements, the lab results, the body camera footage, the 911 call recordings. Everything. You have a constitutional right to see the evidence being used to try and take away your freedom. But you only get that right if you fight the case. If you plead guilty at arraignment, you waive that right. You are agreeing you are guilty without ever seeing the proof. Think about that. You are taking the government's word for it that they have an airtight case. But what if they don't? What if the police report contains a critical error? What if the supposed eyewitness has a criminal record for perjury? What if the body camera footage shows the officer conducted an illegal search? You will never know. You will have slammed the door on your own defense before it ever had a chance to begin. A not guilty plea is the starting pistol for the real legal battle. It forces the prosecutor to prove their case. It's a statement that says, I am presumed innocent until you, the state, can prove beyond a reasonable doubt that I am guilty. It preserves every single one of your constitutional protections. The right to a trial by jury, the right to confront your accusers, the right to remain silent, and the right for your attorney to challenge the evidence. Pleading guilty is the opposite. It's a grand waiver. You are willingly giving up all of those rights in a single moment. You are not just admitting to the act. You are accepting a permanent conviction on your record. And that conviction is a stain that is almost impossible to wash out. We're not just talking about jail time or a fine. We're talking about what are called collateral consequences. That minor drug possession charge you plead guilty to just to make it go away? It could make you ineligible for federal student loans, barring you from getting the college degree you've dreamed of. It could get you kicked out of public housing. It could prevent you from ever getting a license to be a nurse, a teacher, a barber, or a real estate agent. Could affect your child custody case. If you're not a U.S. citizen, it could lead to your deportation, even if you've lived here legally for decades. Pleading guilty isn't an end. It's the beginning of a whole new set of life-altering problems. Now, you might have heard of a third option: no contest, or nolo contendere. This is one of the most misunderstood pleas in the legal system. It sounds like a clever middle ground. You're not admitting you did it, but you're not fighting it either. In reality, for the purposes of the criminal court, a no contest plea is treated exactly the same as a guilty plea. The judge will find you guilty. You will be sentenced. You will have a criminal conviction on your record with all the same collateral consequences. So why does it even exist? Its primary use is to protect you in a potential civil lawsuit. Let's say you're charged with reckless driving after a car accident. If you plead guilty to the criminal charge, the person you hit can then use that guilty plea in their civil lawsuit against you as a direct admission of fault, making it incredibly easy for them to win a judgment for damages. But if you plead no contest, you haven't technically admitted fault. So while you still get the criminal conviction, the other party can't use your plea against you in civil court. It's a very specific tool for a very specific situation, and it's a decision that should never, ever be made without the careful guidance of an attorney who has analyzed every angle of your case. For 99% of people standing at their first arraignment, it's not the right move. So you're standing before the judge. Your heart is pounding. You've either got the lawyer you hired standing beside you, or you've just been assigned a public defender who is whispering in your ear. They will likely speak for you, stating, "Your Honor, my client pleads not guilty to all charges." After that plea is entered, the next critical phase of the hearing begins. The argument over your liberty. The judge has to decide what to do with you while the case proceeds, which could take months or even years. This is the bail hearing. The prosecutor will stand up and make their case. They might argue you are a flight risk, meaning you're likely to disappear and not come back for your next court date. They'll point to things like a lack of a stable job, no family in the area, or a history of missing court dates. They might also argue you are a danger to the community, especially if the alleged crime was violent. They will ask the judge to set a high bail amount, an amount of money you must pay to the court to be released, which you only get back if you show up to all your future hearings. Or in the most serious cases, they'll ask for you to be remanded, held in jail with no bail at all until the trial is over. This is where your lawyer earns their keep. They will immediately counter the prosecutor's arguments. They will paint a picture of you as a responsible, stable member of the community. They will tell the judge about your job, your family, the fact you've lived in the same town your whole life. They will emphasize that you have every reason to see this case through and no reason to run. They will argue for you to be released on your own recognizance, or OR, which is simply a written promise to appear in court without having to post any money. If the judge isn't willing to do that, your lawyer will argue for the lowest, most reasonable bail amount possible. They will also fight against any restrictive conditions of release the prosecutor might ask for, like a GPS ankle monitor, a strict curfew, or a no-contact order with certain individuals. Every argument they make, every fact they present about your life, is designed to convince one person, the judge, that you can be trusted to come back to court and that you are not a threat. Walking out of that courtroom on your own 2 feet, versus being let out in handcuffs back to a jail cell, often comes down to the skill and preparation of the attorney standing beside you. That initial call to the 24-hour hotline, the one that stressed the urgency of getting a lawyer, was for this exact moment. It was the first step in a long journey, a journey that has now officially begun. You've survived the arraignment. You've pleaded not guilty. Your rights are preserved. But as you walk out of the courthouse, blinking in the sunlight, a free person for now, the reality begins to sink in. This is just the beginning. The prosecutor's office is already preparing its case. The next step is to see their cards. The discovery file, containing every piece of evidence against you, is about to land on your lawyer's desk. And what's inside that file will determine the entire strategy for the fight of your life. That file is often called discovery. And it's not just a stack of paper. It's the prosecution's entire playbook, handed over to your defense attorney. In the federal system, it's governed by Rule 16 of the Federal Rules of Criminal Procedure. In state courts, similar rules apply. The law says the government can't play gotcha. They can't hide the evidence they plan to use against you. They have to show their hand. And when that box arrives, your lawyer doesn't just see documents. They see a story. A story the prosecution has carefully crafted to paint you as the villain. The lawyer's job is to read that story, find the plot holes, identify the unreliable narrators, and locate the scenes that were conveniently left on the cutting room floor. First, they'll pull out the police reports. These are the foundation of the state's case. The arresting officer's narrative, witness summaries, the initial incident report. A novice just reads the words. A great lawyer reads the gaps between the words. They're looking for inconsistencies. Did Officer Smith's report, written 3 hours after the incident, perfectly match his partner's report, written a day later, down to the exact phrasing? That's not good police work. That's a red flag for collaboration, for creating a neat, tidy story after the fact. Did the report mention you were agitated and uncooperative? Or does that just mean you were scared and asking for a lawyer? The lawyer scrutinizes every adjective, every timeline, every claim, cross-referencing it with everything else in the file. They're looking for the subtle biases and shortcuts that can crumble the very foundation of the case. Next come the witness statements. This is pure human drama. You've got the alleged victim's statement, often emotional and compelling. You've got the eyewitness who saw something from 100 feet away at night for 3 seconds. You might even have a statement from a friend or a neighbor, someone you trusted, whose words now feel like a profound betrayal. Your lawyer reads these not for truth, but for weakness. How reliable is human memory, really? Studies show it's incredibly fallible. Was the witness coached? Do they have a motive to lie? Does their statement contradict another witness's statement? Or even their own statement given on a different day? The lawyer is looking for leverage. That one witness who says the getaway car was blue when everyone else said it was green? That's not just a detail. That's a seed of doubt, and a lawyer's job is to plant that seed in the mind of a jury and water it until it grows into a forest of reasonable doubt. Then you get to the hard science, or what's supposed to be hard science. The forensic evidence. This is the stuff that looks so convincing on TV. DNA analysis, fingerprint reports, ballistics tests, the drug lab chemistry report. It comes with an air of infallibility, but your lawyer knows better. They're not just looking at the result, they're looking at the process. They'll demand the chain of custody documents for every single piece of evidence. This is a log that tracks the evidence from the moment it was collected. Who had it? Where was it stored? Who touched it? A single unexplained gap in that chain, a single missing signature, can render that slam-dunk DNA evidence completely inadmissible in court. They'll also scrutinize the lab reports themselves. Was the equipment calibrated? What was the lab's error rate? They might even hire their own expert to retest the evidence, because sloppy lab work and contaminated samples are far more common than you think. And in today's world, the most dangerous part of the discovery file is often the digital evidence. Your life is an open book, and the prosecution has a library card. They have your text messages, stripped of all tone and context. That sarcastic joke you made to a friend? It's now Exhibit A, presented as a cold-blooded confession. They have your social media posts, your location data from cell towers, your search history. They will weave a narrative from digital breadcrumbs that can make an innocent person look guilty. But this is a double-edged sword. Your lawyer is looking for the same thing. They're hunting for the body camera and dashcam footage the police report forgot to mention. That footage is often the most objective witness in the entire case. It can show the police violating your rights during a search. It can show that your demeanor was calm and respectful, not agitated and uncooperative. It can be the one thing that proves the official report is a work of fiction. As your lawyer sifts through this mountain of information, they are on a very specific type of treasure hunt. They are looking for something called Brady material. Named after a landmark 1963 Supreme Court case, Brady v. Maryland, this is the legal dynamite that can blow a prosecutor's case to pieces. The Brady rule mandates that prosecutors must turn over any evidence they possess that is exculpatory, meaning any evidence that could be favorable to you, the defendant. This could be evidence that suggests someone else committed the crime. It could be information that damages the credibility of a key prosecution witness, like the fact that their star eyewitness has a history of perjury or was offered a deal in exchange for their testimony. Finding a Brady violation, proving the prosecution hid evidence that could have helped you, isn't just a win. It's a game changer. It can lead to cases being dismissed, convictions being overturned, and it can expose the rot of prosecutorial misconduct. For you, the client, seeing this file is a brutal, gut-wrenching experience. It's seeing your life, your character, your very freedom, reduced to a collection of cold, accusatory documents. It's reading the words of people you know, twisted and weaponized against you. It's a calculated effort to dehumanize you, to make you look like a monster, a statistic. This is the moment the weight of the entire system feels like it's crushing you. But for your lawyer, this is the moment the fog of war begins to clear. The fear of the unknown is replaced by a clear-eyed assessment of the battlefield. They see the prosecution's strengths, but more importantly, they see the cracks in the armor. They see the overconfident witness, the sloppy police work, the questionable lab report, the missing footage. The discovery file is not an indictment carved in stone. It is a roadmap. It tells your lawyer exactly where the prosecution plans to attack. And by showing them the path of attack, it also reveals the paths for the counterattack. Every weakness they find is a target. Every inconsistency is an opportunity. Every piece of missing evidence is a question they will force the prosecution to answer in front of a jury. The initial shock and despair of seeing the case against you transforms into a strategic plan. The defense is no longer just a reaction, it becomes an action. Now your lawyer knows who to investigate, what evidence to challenge, and which legal motions to file to start dismantling the prosecution's case, piece by painful piece, long before a jury is ever selected. The state has shown its cards. Now it's time to start taking their pieces off the board. And the first piece you go after is often the most important one, the evidence itself. This is where the real legal chess match begins, through a series of powerful maneuvers called pretrial motions. Think of a motion as a formal request to the judge, asking them to make a ruling on a specific issue before the trial even starts. And the most devastating motion in a defense attorney's arsenal is the motion to suppress evidence. This motion is a legal nuke. It doesn't just argue that the evidence is weak. It argues that the evidence was obtained illegally, in violation of your constitutional rights, and therefore, it cannot be used against you at all. It's like telling the other chess player that their queen was never legally on the board to begin with. Let's go back to that DUI stop. Remember how the hotline lawyer told you to be polite, but to say as little as possible? Let's imagine the scenario played out slightly differently. Let's say the officer, frustrated by your lack of a confession, decides to search your car without a warrant, without your consent, and without probable cause. He finds a legally prescribed medication in your glove compartment, in its proper bottle, but decides to list it in his report as suspicious pills found in vehicle, hoping to paint a darker picture. You tell your retained attorney this, recalling the advice from the hotline. Your lawyer's eyes light up. This is it. This is the crack in the foundation. They file a motion to suppress based on a violation of your Fourth Amendment, right against unreasonable searches and seizures. Now, you're not in front of a jury. You're in a much quieter, more intense setting. A suppression hearing. It's just you, your lawyer, the prosecutor, the judge, and the arresting officer on the witness stand. And your lawyer gets to cross-examine that officer. Every detail of the stop is put under a microscope. Officer, did my client give you consent to search his vehicle? No. Did you have a warrant to search the vehicle? No. So, on what basis did you conduct the search? The officer might try to argue he had probable cause. Maybe he'll claim he smelled marijuana or saw something in plain view. But a skilled attorney, prepped by the initial facts you provided thanks to that hotline call, will pick that story apart. They'll use the officer's own body cam footage, his police report, and the dispatch logs to show inconsistencies. They will expose the search for what it was, a fishing expedition that violated the highest law of the land. And if the judge agrees, bang, the motion is granted. The suspicious pills are suppressed. They legally cease to exist in the context of your case. The prosecutor is forbidden from mentioning them, the officer can't testify about them, and the jury will never, ever know they were found. This brings us to a crucial legal concept called fruit of the poisonous tree. It's a powerful doctrine that says if the source of the evidence, the tree, is tainted by illegality, then anything that comes from it, the fruit, is also tainted and inadmissible. Let's say after finding those pills, the illegal search led police to get a warrant to search your house, where they found something else. If the initial car search was illegal, the poisonous tree, then the evidence found at your house, the fruit, would also be suppressed, because it was only discovered as a result of the first constitutional violation. One single mistake by law enforcement identified early can cause the entire case against you to unravel chain reaction style. Sometimes, a motion to suppress is so successful that it guts the prosecution's entire case. Without their key evidence, they have nothing left. At that point, your lawyer might file the ultimate pretrial motion, a motion to dismiss. This is the checkmate. This is asking the judge to throw the entire case out of court for good. This can happen if evidence is suppressed, if the prosecution has violated your right to a speedy trial, or if it becomes clear that there simply isn't enough evidence for any reasonable jury to possibly convict you. Now, in the vast majority of cases in the American justice system, the final battle isn't fought in a packed courtroom in front of a jury. It's fought at a negotiating table. This is the world of plea bargaining. And everything we've just talked about, the discovery, the investigation, the motions, is all ammunition for this negotiation. Plea bargaining has a bad reputation. People picture innocent individuals being forced to plead guilty to crimes they didn't commit. And while that can happen, that's not the strategic reality for most cases. A plea bargain is a deal between the defense and the prosecution. The defendant agrees to plead guilty, usually to a lesser charge, in exchange for a more lenient sentence than they would risk getting if they went to trial and lost. Why do prosecutors offer deals? Because their resources are limited. They can't take every single case to trial. It would grind the entire system to a halt. They need to close cases efficiently. More importantly, a trial is always a gamble for them, no matter how strong they think their case is. A jury is unpredictable. A not guilty verdict is a total loss for the prosecution. A plea deal, on the other hand, is a guaranteed conviction on their record. So, how does that first call to a 24-hour hotline influence this? Massively. By getting a lawyer involved immediately, you started building your defense from minute one. Your lawyer used discovery to find the weaknesses in the state's case. They filed motions that put the prosecutor on the defensive. Imagine the prosecutor's initial position. They have the police report and it looks solid. They make an initial offer. Plead guilty to the felony DUI, and will recommend 5 years in prison. It's a scare tactic. But now your lawyer walks into the prosecutor's office and lays their cards on the table. Your key witness, the supposed victim, has a history of making false reports, which we found in our investigation. Your arresting officer's body cam footage contradicts his written report about the field sobriety test. And we have a pending motion to suppress the breathalyzer results because the machine wasn't calibrated correctly. And we have the maintenance logs to prove it. Suddenly, the prosecutor's slam dunk case looks like a house of cards in a hurricane. The risk of them losing at trial has just skyrocketed. The power dynamic in the room has completely shifted. The negotiation starts again. Okay, the prosecutor might say, what if we drop the felony to a misdemeanor? No prison time, just probation. This is the art of the deal. It's a calculated dance of risk and reward. Your lawyer's job is to show the prosecutor that going to trial is a bigger risk for them than it is for you. Every piece of doubt, every procedural error, every constitutional violation your lawyer uncovers becomes a bargaining chip. The final decision, however, always rests with you. This is one of the most agonizing choices a person can face. Your lawyer can only advise you. They can say, I believe we have an 80% chance of winning at trial. But if we lose that 20% chance, you could face 10 years in prison. The prosecutor is now offering a deal for 1 year of probation and a fine. The choice is yours. Do you take the guaranteed freedom, even if it means accepting a conviction for something you feel you're not truly guilty of? Or do you roll the dice and fight for total vindication, knowing that if you lose, the consequences could be catastrophic for your life? This is where the human element of law collides with the cold, hard calculus of the system. It's a decision weighed down by finances, family, fear, and the fundamental desire for justice. And the strength of your position in that critical, life-altering negotiation often traces all the way back to the clarity and strategy you gained in the first few hours from that one crucial phone call. But what if the prosecutor refuses to budge? What if they're so convinced of their case or so politically motivated that they won't offer a fair deal? Then there's only one path left. You're not just preparing for a negotiation anymore. You're preparing for war. You're going to trial. And suddenly the game changes completely. The conference rooms and polite letters are gone. This is no longer a negotiation. It's a campaign. The courtroom is the battlefield. And the months leading up to it are a grueling strategic war of attrition. This phase is called pretrial, and it's where 90% of the work is done, and where most cases are truly won or lost long before a jury is ever called. The first and most important stage of this campaign is discovery. Now, if you've watched any legal drama on TV, you probably think a trial is all about surprise witnesses and gotcha moments. The reality is the exact opposite. The American legal system is built on a principle of radical transparency. The goal of discovery is to eliminate surprises. Each side is legally required to show the other side almost every single card in their hand, all the evidence, all the witnesses, all the arguments they plan to make. The idea is that if both sides know everything, they'll have a much clearer picture of the truth, which might just lead them back to a reasonable settlement. But in practice, it's a high-stakes, strategic information war. It begins with something that sounds deceptively simple: written discovery. This is a blizzard of paperwork designed to extract information and lock the other side into a story. First, you have interrogatories. These are written questions that the other party must answer in writing, under oath. And these aren't simple questions. They are surgically precise. It's not what happened. It's identify every person who was present at the scene of the collision. State, in chronological order, every medical provider you have sought treatment from for the injuries alleged in this lawsuit. Describe with specificity the location of your hands, feet, and eyes in the 3 seconds immediately preceding the impact. Each answer is a brick in the wall of your case. An answer given under oath is binding. If they try to change their story later on the witness stand, your lawyer will be waiting with that piece of paper, ready to destroy their credibility. Next comes the request for production of documents. This is exactly what it sounds like. Your lawyer demands the other side turn over every relevant piece of paper, every file, every digital record. This is the treasure hunt. In your car accident case, your lawyer demands the maintenance records for the delivery truck that hit you. The company's lawyers might send back a mountain of paper, hoping you miss it. But your legal team sifts through every page, and there it is. A note from a mechanic 3 weeks before the crash saying the brakes are spongy and need immediate replacement, but the work was never done. That single piece of paper can be the key that unlocks a multi-million-dollar verdict. It's the email a manager sent saying, "We need to cut corners on safety to meet our quarterly goals." It's the text message the other driver sent 2 seconds before the crash. This is the search for the smoking gun. Then there are requests for admission. These are powerful, simple statements the other side must either admit or deny. Admit you were the registered owner of the vehicle involved in the collision. Admit you received a traffic citation at the scene. Admit that you did not have your headlights on. The goal is to narrow down the issues. If they admit it, that fact is now considered proven for the rest of the case. We don't have to waste time arguing about it at trial. If they deny something you can easily prove, like that they own the car, it makes them look foolish and dishonest to a judge and jury. But the most intense, the most human part of discovery is the deposition. This is the closest you get to a courtroom before the trial itself. You, the opposing party, and key witnesses are all required to sit in a conference room, raise your right hand, and answer questions from the opposing lawyer face-to-face for hours on end. A court reporter is there, typing down every single word, every stutter, every sigh. It is grueling, it is stressful, and it is absolutely critical. For your lawyer, deposing the defendant driver isn't just about getting facts. They already have most of the facts from the police report and written discovery. The deposition is about something more. It's a test drive. How does this person perform under pressure? Are they arrogant? Are they sympathetic? Are they a liar? Do they get angry easily? Your lawyer is trying to figure out what a jury will think of this person. At the same time, the defense lawyer is doing the same thing to you. They will ask you to describe the accident in excruciating detail. They will comb through your medical history, your work history, your personal life, looking for any inconsistency, any weakness they can exploit. They want to see if you'll crack. They want to know if a jury will believe you, if they will root for you. A case can be made or broken in that sterile conference room. A witness who seems credible on paper might completely fall apart during a deposition, forcing their side to immediately seek a settlement. While this war of information is raging, another war is being fought on paper, the motion practice. Motions are formal requests for a judge to make a ruling and shape the case. The defense will almost always file a motion to dismiss early on, arguing that even if everything the plaintiff says is true, it doesn't add up to a valid legal claim. It's an attempt to get the case thrown out of court before it even starts. Most of the time it fails. But the big one is the motion for summary judgment. This usually comes after discovery is complete. The defense lawyer goes to the judge and says, "Your Honor, we've seen all their evidence. They've seen all our evidence. And there is no genuine dispute about the key facts. The facts are so overwhelmingly in our favor that no reasonable jury could ever find for the plaintiff. So you should skip the trial and just grant judgment for us right now." This is a knockout blow. If the judge grants the motion, your case is over. If the judge denies it, it's a huge victory for you. It means the judge agrees that you have enough evidence to let a jury decide. A denied summary judgment motion sends a powerful message to the other side, and often sends them scurrying back to the negotiating table with a much better offer. Then there are the strategic motions, the motions in limine. This is where lawyers fight over what the jury will and will not be allowed to hear. Your lawyer might file a motion to prevent the defense from mentioning that you were divorced 10 years ago, arguing it's completely irrelevant and would only serve to prejudice the jury against you. The defense might file a motion to prevent your doctor from using a certain medical term, arguing it's inflammatory. This is about controlling the narrative. It's about sanitizing the battlefield before the troops, the jury, even arrive. Each victory and each loss in this paper war shapes the final confrontation. This entire pretrial process is a marathon, not a sprint. It can easily take a year, 2 years, or even longer. It's an exhausting, emotionally draining ordeal designed to test the resolve of everyone involved. You'll be forced to relive the worst moments of your life, have your character questioned, and your life placed under a microscope. It's also incredibly expensive. While you aren't paying your lawyer by the hour, the costs are piling up. Deposition transcripts, expert witness fees, court filing costs. These can run into the tens or even hundreds of thousands of dollars, all fronted by your law firm. This immense pressure, the time, the emotional toll, and the financial risk, is precisely why over 95% of cases settle before trial. Both sides see the full strength and weakness of their opponent's case. They test each other's resolve, and they realize that a trial is an enormous, unpredictable gamble. But if you withstand the pressure, if your case survives the motions, and if the other side still refuses to offer a fair resolution, then the final preparations begin. Your lawyer will assemble trial binders, prepare witness examinations, and craft the opening and closing statements. You'll meet with the judge for a final pre-trial conference to iron out the last-minute details. And then you'll finally be ready for the day it all leads to. The day you select the citizens who will hold your future in their hands. The day you begin the process of picking your jury. This is no longer a world of paperwork and motions. This is a world of people. And the entire outcome of your case now rests on your lawyer's ability to read them. This process, known as voir dire, is one of the most misunderstood, yet critically important phases of any trial. The term is French, and it literally means to speak the truth. And that's the goal. To get a room full of strangers to speak their truth, so you can uncover the one thing that can poison a case from the start. Bias. It begins with a summons. Dozens, sometimes hundreds, of people from your community receive a letter ordering them to appear for jury duty. They are the jury pool, or the venire. They file into the courtroom, a cross-section of your world. Teachers, mechanics, retirees, students, all of them wondering why they're there and when they can leave. They are the audience for the first act of this legal drama. And from them, your lawyer must find the 12 who will not just hear your story, but fairly judge it. The process often starts with a written questionnaire. It asks the basics: name, occupation, marital status. But it quickly digs deeper. Have you or a family member ever been the victim of a crime? Have you ever been sued? Do you have any training in law or medicine? What newspapers do you read? What are your favorite TV shows? These questions are designed to create a preliminary sketch of each person. A prosecutor might see CSI fan and think, good, they're interested in forensics. Your defense attorney might see the same thing and worry. They might have unrealistic expectations about evidence because of television. Every answer is a clue. Then comes the verbal questioning. The judge usually goes first, asking broad questions to the group. Can you be fair and impartial to both sides? Everyone nods. Do you understand that the defendant is presumed innocent? Everyone nods again. But this is just the warm-up. The real work begins when the lawyers stand up. This is where legal skill transforms into a raw, intuitive art of human psychology. It's less like a job interview and more like a high-stakes poker game where the lawyers aren't just playing the cards. They're trying to figure out who the other players are, deep down. Your lawyer and the prosecutor are both searching for bias, but they're looking for completely different kinds. The prosecutor is looking for anyone who might be skeptical of authority, who distrusts the police, or who might be overly sympathetic to someone in your position. They're looking for jurors who see the world in clearer terms of right and wrong, who believe in rules and consequences. An engineer, an accountant, a military veteran, these might be archetypes a prosecutor is drawn to. Your defense attorney is on the hunt for the exact opposite. They're searching for jurors who are open-minded, who can see shades of gray, who might be naturally skeptical of the government's version of events. They're looking for empathy. A social worker, a nurse, a teacher, an artist, these might be the profiles your lawyer hopes to find. Someone who understands that life is messy and people make mistakes. The questions they ask can feel intensely personal. Mr. Smith, I see you're a manager. Have you ever had to fire someone? How did that make you feel? The prosecutor isn't asking because they care. They're trying to gauge how Mr. Smith handles difficult decisions and authority. Ms. Jones, you mentioned you have a son who's 25. Has he ever had a run-in with the law? Even something minor like a speeding ticket. Your lawyer isn't being nosy. They're trying to see if she might have a personal, emotional connection to the justice system that could make her more sympathetic to your side. They're watching everything. Not just the answers but how they're answered. Did the person cross their arms when the police were mentioned? Did their eyes dart to their spouse when asked about their views on a controversial topic? Did they hesitate before answering a simple question? Every gesture, every pause, every inflection is a piece of the puzzle. As the lawyers gather this information, they have two tools to shape the jury. The first is a challenge for cause. If a potential juror says something that proves they cannot be impartial, like, "My brother is a police officer, and I'll believe any police officer over anyone else, or I've read about this case in the paper and I already think he's guilty. The lawyer can ask the judge to dismiss them for cause. If the judge agrees that the juror is demonstrably biased, that person is gone. There is no limit to the number of challenges for cause. But the real strategy lies in the second tool, the peremptory challenge. Each side gets a limited number of these. Think of them as wild cards. A lawyer can use a peremptory challenge to strike a potential juror for almost any reason at all, without having to explain it. It can be a gut feeling. It can be a strange look. It can be the way they're dressed. Maybe your lawyer just didn't like the vibe they were giving off. Maybe a juror reminded them of a stubborn uncle who never listens to reason. As long as the reason isn't discriminatory, they can be removed. And that's a critical point. The Supreme Court, a case called Batson v. Kentucky, ruled that you cannot use a peremptory challenge to remove a juror solely because of their race, ethnicity, or gender. If the prosecutor, for example, uses all of their strikes to remove every black person from the jury pool, your defense attorney can raise a Batson challenge. The prosecutor would then have to provide a credible, race-neutral reason for each of those strikes. It's a safeguard, a crucial check on the power of these challenges to ensure the jury reflects a fair cross-section of the community. The process is one of elimination. Person by person, the pool of strangers shrinks. A challenge for cause here, a peremptory strike there. The lawyers on both sides are constantly recalculating, reevaluating their strategy. If I strike this person, who is next in line? Is that person better or worse for my case? It's a tense, quiet battle of wits. The people being questioned often have no idea why they are being kept or dismissed. They just answer the questions, and then are either told to take a seat in the jury box or that they are free to go. Slowly, painstakingly, 12 seats are filled. Then, a few more for alternates in case one of the main jurors gets sick or has to be excused during the trial. And then it's over. The selection is final. The unchosen are thanked and sent home. The chosen are sworn in. They raise their right hands and take an oath to well and truly try the matter, and a true verdict render according to the evidence. And in that moment, everything changes. They are no longer just a collection of individuals. They are the jury. They are 12 strangers who now hold your fate in their hands. They will hear every word, see every piece of evidence, and in the end, they will retreat into a private room and decide your future. All the strategy, all the psychology, all the months of preparation have led to this point. The stage is set. The audience is seated. And once those 12 faces are looking back at you, the real performance begins. The curtain rises, the judge gives the instruction, and the first words of the trial are spoken. The opening statements. Opening statements are not about arguing. They're not about proving anything. An opening statement is a promise. It's the trailer for the movie the jury is about to watch. The prosecutor or the plaintiff's attorney goes first. They stand before the jury, make eye contact with each of the 12, and they tell a story. They'll say, "This is a case about a promise that was broken." Or over the next 3 days, the evidence will show that on the night of June 12th, the defendant made a choice. It's a roadmap. They are giving the jury a framework, a lens through which to view all the evidence that will follow. They are setting the scene, introducing the characters, and foreshadowing the conclusion. They'll point to the defendant and say, "The evidence will prove beyond a reasonable doubt." They will point to their own client and say, "You will hear from Sarah herself about the life she lived before this happened." It's powerful. It's pure narrative. Then the defense gets their turn. They might offer their own competing story. Or they might just sow the seeds of doubt. They might say, "The prosecutor has told you a very compelling story. It's a neat story, but it's not the whole story." As you listen to the evidence, I want you to ask yourselves, what are they not telling you? What pieces don't fit? The defense's goal is to give the jury a different lens, a lens of skepticism. They remind the jury that the burden of proof isn't on them. The defendant doesn't have to prove their innocence. The state has to prove their guilt. And if they can't, the only verdict is not guilty. With the two competing movie trailers presented, the movie itself begins. The prosecution or the plaintiff in a civil case always goes first. They have what's called the burden of proof. It's their job to build a case brick by brick in front of the jury. They do this by calling witnesses. A witness is sworn in, takes the stand, and the attorney who called them begins what's called direct examination. The goal of direct examination is to let the witness tell their story. The lawyer is just a guide. The questions are open-ended. Where were you on the night of the incident? What did you see? Can you describe the vehicle for the jury? What happened next? The lawyer is essentially invisible, just teeing up the witness to paint a picture for the jury. Through this questioning, evidence is introduced. The lawyer might show the witness a photograph. Do you recognize this? Yes, that's the intersection where the crash happened. Is this a fair and accurate depiction of how it looked that day? Yes. And then the lawyer turns to the judge and says, "Your Honor, I'd like to offer this photograph as People's Exhibit 1. The defense might object, but if they don't, or if the judge overrules them, that photo is now officially evidence. It gets passed to the jurors who can hold the story in their hands. This process repeats. Witness after witness. A police officer, a paramedic, an eyewitness, an expert. Each one adds another brick to the wall of the prosecution's case. But for every action, there is an equal and opposite reaction. After the prosecutor finishes questioning their witness, the defense attorney stands up. It's time for cross-examination. And the entire energy in the room shifts. If direct examination is a gentle conversation, cross-examination is an interrogation. The goal is not to let the witness tell their story. The goal is to dismantle the story they just told. The defense attorney is now in complete control. The questions are no longer open-ended. They are sharp, pointed, and leading, designed to be answered with a simple yes or no. You were over 200 feet away, correct? It was dark, wasn't it? You had just finished a 10-hour shift, yes? So you were tired, weren't you? The lawyer is the one telling the story now, and the witness is just there to confirm the details. The strategy is to poke holes, to find inconsistencies, to challenge the witness's memory, their perception, their credibility, to make the jury think, maybe I didn't get the whole picture before. This is where the real courtroom drama happens. The back and forth can get heated, and you'll hear those words you know from television. Objection. An attorney objects when they believe the other side is breaking the rules of evidence. There are dozens of reasons to object, but you often hear the same few. Objection, Your Honor. Hearsay. This is a big one. Hearsay is, in simple terms, an out-of-court statement being used to prove that what it says is true. You can't have a witness testify. My neighbor told me he saw the defendant do it. Why? Because the defense can't cross-examine the neighbor. The jury needs to hear it straight from the horse's mouth. The person who saw it has to be the one on the stand. Another common one is objection. Leading. You can't ask leading questions of your own witness on direct examination. You can't say, "You saw a red car run the light, didn't you?" You have to ask, "What did you see?" But on cross-examination, leading questions are not only allowed, they're the entire point. When an attorney objects, the judge acts as the referee. They'll either say sustained, which means I agree the objection is valid, the other lawyer needs to stop, or they'll say overruled, which means I disagree, the question is fine, the witness must answer. This judicial refereeing ensures the fight stays within the rules. After the prosecution has called all of its witnesses and presented all of its evidence, the lawyer will stand and say the 5 words that signal the halfway point. The prosecution rests its case. This means they believe they have met their burden of proof. They have built their wall, brick by brick, and they believe it's strong enough to stand. Now the spotlight turns to the defense. A critical point here. The defense doesn't have to do anything. In the American system, you are innocent until proven guilty. The defense doesn't have to prove innocence. They only have to show that the prosecution failed to prove guilt. They could, in theory, stand up and say, "The defense rests," without calling a single witness, and then argue in their closing that the prosecution's case was too weak. But that rarely happens. Usually the defense presents their own case. They call their own witnesses to the stand. Maybe it's an alibi witness who can testify the defendant was somewhere else. Maybe it's their own expert witness, an accident reconstructionist who will testify that the physical evidence shows a different story than the one the prosecution's expert told. The process is the same. The defense lawyer conducts a direct examination of their witness, telling their side of the story. And then, the prosecutor gets their turn at cross-examination, trying to poke holes in the defense's narrative. The trial becomes a battle of stories. Each side presents its own version of reality. Evidence that supports one story is minimized or explained away by the other. A witness who seems credible to one side is painted as a liar or a fool by the other. The jury sits there watching it all. They are the silent arbiters of truth. They watch the lawyers, they watch the witnesses, they watch the defendant. They look at the photos, the documents, the charts. They are absorbing millions of data points, both verbal and nonverbal. Think about the person at the center of this, the person who made that first call to a 24-hour hotline, terrified and confused. Now they sit in a hard wooden chair, watching their life, their choices, their character be picked apart, analyzed, and reassembled into two completely different narratives. It is a grueling, dehumanizing, and utterly terrifying process. Every question, every objection, every glance from the jury feels like it carries the weight of their entire future. Finally, the last defense witness steps down. The last piece of evidence is entered. The defense attorney stands and says, "The defense rests. The evidence portion of the trial is over. All the facts, or at least the alleged facts, are on the table. The competing stories have been told. The jury has seen the raw materials. They've seen every brick, every piece of lumber, every nail that both sides will use to build their case. But a pile of materials isn't a house, and a pile of facts isn't a verdict. The jury is now swimming in a sea of conflicting information. What are they supposed to do with it all? How do they make sense of the chaos?" That's where the lawyers come back in. The evidence is closed, but the battle is far from over. Because now it's time for the closing arguments. It's time to stop just presenting the facts and start arguing what they mean. The final performance is about to begin.